The hearing will now come to order. Today's hearing is on EPA enforcement priorities and practices. I would note that we had expected Dr. Al Armendariz to testify here today. He's the former Region 6 administrator, and we were disappointed that he chose to cancel yesterday afternoon. We do intend to explore the reasons for his failure to appear. As I said, the title of today's hearing is EPA Enforcement Priorities and Practices. And I hope that at least one result of this hearing will be, when it's over, that Administrator Jackson and some others at EPA will think more about working in a cooperative attitude and spirit with the entities and the states that they deal with, rather than an adversarial attitude and spirit. Now, why do I say that? Well, I'm going to give you some examples. Number one, Mr. Armendariz himself. We all know the statement that he made before a city council meeting in Texas, in which he said when the Romans went into a community, they would find 5 citizens and they would crucify them, and after that they wouldn't have any trouble. And he said that's what we need to do in the oil and gas industry. That is not the type of attitude we need from public employees. In the Range Resources case, which is another example of the approach to enforcement that concerns us, in that case, EPA issued an emergency compliance order against a drilling company based on false accusations. Even though Texas regulators warned EPA it was premature and the facts were not known, in the end, EPA did withdraw the order, but not until after the company was forced to spend millions of dollars to defend itself against EPA's false claims. EPA's efforts relating to the Texas flexible air permits provide another example of aggressive and unprecedented regulatory actions. This permitting program had been in effect since President Clinton's administration and was working very well to improve the state's air quality. EPA took upon itself to federalize this program and compel more than 100 major facilities to go through a process EPA called deflexing. It isn't just congressional Republicans who think that EPA is overreaching. An increasing number of federal judges do also. In the recent Sackett decision, the Supreme Court unanimously rejected EPA's efforts to deny due process to landowners. One of the judges wrote that the position taken in this case by the federal government would have put the property rights of ordinary Americans entirely at the mercy of Environmental Protection Agency employees. He further said that in a nation that values due process, not to mention private property, such treatment is unthinkable. In another case, the Luminant case, in the Fifth Circuit Court of Appeals, that court rejected EPA's attempts and said that EPA's disapproval was based on purported nonconformity with 3 extra statutory standards that EPA had created itself out of whole cloth. In the recent Spruce Mine case decision, another federal judge invalidated an attempt by EPA to rescind a coal mining permit. The court called EPA's rationale magical thinking and a stunning power for an agency to arrogate to itself. And in the Avenal case last year, a court rejected EPA's claim it was not bound by the Clean Air Act's statutory requirement to make a permitting decision with 1 year. The court said the EPA's self-serving misinterpretation of Congress's mandate is too clever by half, and it's an obvious effector to protect its regulatory process at the expense of Congress's clear intention. And then the court went on to say, put simply, that dog won't hunt. So we believe that many of us believe EPA is out of control. They're more interested in being an adversary than working in a cooperative spirit. And so that's what we hope to explore in today's hearing. And at this time, I'd like to yield 2 minutes to the gentleman from Oklahoma, Mr. Sullivan.
Thank you, Chairman Whitfield. Thank you for holding this important hearing today to discuss the enforcement practices and priorities of the U.S. Environmental Protection Agency. Today, we will be taking a critical look at some of these enforcement practices in EPA Region 6, which includes my state of Oklahoma. I'm pleased to welcome my good friend, Bob Sullivan. who is chairman of the Oklahoma Independent Petroleum Association. He is with us to discuss the importance of fossil fuels to our nation and to share his real-life business experiences with EPA Region 6's enforcement practices on oil and gas producers. Thank you for your advocacy on oil and gas issues at both the state and federal level. I'm extremely disappointed that former EPA Region 6 Director, Dr. Al Armendariz, decided to cancel his appearance at today's hearing at the last minute, and I think I know why. The American people deserve an honest explanation for his comments saying that the EPA should crucify and make examples out of oil and gas companies which employ over 9 million Americans. This type of regulatory bullying and abuse underscores the problems we face with EPA's enforcement culture. Like many Americans, I'm pleased that Mr. Armendariz resigned after publicly expressing such hostility and political prejudice towards oil and gas companies, an industry that employs over 300,000 Oklahomans in my state. This blatant political bias is completely unacceptable behavior from a now former government official charged with regulating this critical industry. The Obama administration's refusal to fire Mr. Armendariz is proof that they are out of touch with the American people when it comes to developing a national energy policy. While I supported Mr. Armendariz's decision to resign, I also challenged the EPA to go even further to root out this troubling trend of hostility towards oil and gas production in order to achieve our goal of powering our nation with affordable and stable sources of American-made energy. Mr. Chairman, I yield back the balance of my time.
This time I recognize the ranking member, Mr. Rush, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, I am really I'm very disturbed at this hearing. Since the beginning of the 112th Congress, by my count, we've had over 30 Energy and Power Subcommittee and Joint Committee hearings, over 30. And we've held over a dozen subcommittee and full committee markups. And we've had 9 bills that originated from this subcommittee that have been voted on by the full House. Yet, from all that time and all that effort and all that the taxpayers' dollars that have gone into all of this, this subcommittee has produced exactly 1 bill. Let me repeat, 1 bill, the Pipeline Safety Reauthorization Act, that has actually become law. Now here we go again. Mr. Chairman, when will the other side understand that the EPA stands for the Environmental Protection Agency and not every problem in America agency? EPA is Environmental Protection Agency, not the Every Problem in America agency. While attacks on the EPA and the Clean Air Act may appease some of the more extreme constituencies that the majority side represents, most American people, particularly those who are facing economic crises in their lives, in their families, in their homes, and in their neighborhoods, they want to see us working on in a bipartisan manner to address critical issues such as access to jobs, clean air, clean water, less dependency on foreign oil, enhanced energy efficiency measures, and an increased reliance on cleaner and renewable energy sources for the future. Those are the issues they want us to be working on, not some comment that some unemployed or some ex-member of EPA who is no longer in government, not someone who is no longer a part of the federal government. They don't want us to focus on some stupid statement that he made some time ago. They want us to focus on the issues that's before them right now and the issues that they're concerned about. But yet, here we are, cameras all over the place, showing off, showing how angry we are about the statement that's taken out of context of an ex-government employee, a former EPA staffer, who's gone on with his life and won't be here. I'm pretty sure he won't be here ever again. But why are we wasting time? You know, you want an opportunity to profile and parade before the cameras? You want an opportunity to try to embarrass the Obama administration? Well, I think we're the ones who should be embarrassed. Because we know that not one constructive thing is going to happen today. Not one thing. Not one scintilla of solution for the American people is going to come out the time that we're wasting here today. Mr. Chairman, with all due respect to the witnesses who are here, I believe our time would be better served by working in a bipartisan manner to enact policy that someday may actually move this nation and this energy agenda forward. Mr. Chairman, I thank you, and I want to yield the balance of my time to my friend from Texas.
Thank you, Mr. Chairman. I want to thank our ranking member for yielding me time in holding this hearing. I want to first welcome two of Texans on from our committee, both our chair of our Texas Railroad Commission, and actually regulates oil and gas in Texas, Barry Smithman. I've known Barry's family for decades and a good family, Houston family, although I know Hill Country now. But and also the chair of our Texas Commission on Environmental Quality, Brian Shaw. I regret the reason we're holding this hearing today, and I had planned to praise Dr. Armendariz for agreeing to testify since he resigned, but canceling at the last minute is disrespectful to our committee, and some of us who actually remember a subcommittee hearing we had in Houston that our regional administrator couldn't appear, but he was literally 2 blocks from our hearing there at South Texas College of Law. I'm disappointed he chose not to do it, but I want to thank our other panelists for being here, especially our Texas witnesses. The oil and gas industry has been and will continue to be a vital economic engine for our country, and EPA officials should not use negative language against the oil and gas industry without cause. While Dr. Armendariz's comments may have been meant as an analogy, if you take them in context of actions taken by EPA Region 6, they reveal a troubling trend of hostility toward oil and gas production, literally in Texas, Oklahoma, and Louisiana, and New Mexico, that produces a significant amount of the product our country needs. I'm sure many of you saw the Associated Press article last week by Dana Capillo. Dana ran extensive analysis of enforcement data over the past decade and found the EPA went after producers more often under the Bush administration than under this administration's. I think that's fine and good, but I also think it speaks volumes about the great care our companies are putting into ensuring their exploration and production activities do no harm to the environment, given the number of wells that actually increased in recent years. However, the AP numbers didn't reflect violation notices, emergency orders, which have been a true problem within this current administration. And take, for example, what famously happened in Parker County. The EPA preempted the Railroad Commission, issued an emergency administrative order alleging the hydraulic fracking had made the water unsafe when the data did not support the EPA's claim. Ms. Capello's numbers also don't reflect Dr. Armendariz's choosing to attend that conference literally 2 blocks away from our Energy and Commerce Energy Subcommittee hearing when we were discussing EPA's decision to disapprove the Texas Flexible Air Permit Program. The hearing and the forum were just blocks away, and these instances tell a very different story, and I regret Dr. Armendariz is not here to explain his rationale. Mr. Chairman, I hope this hearing is constructive and we can move forward, not only Region 6, but our effort in our committee to produce the energy that our country needs, and I yield back my time.
Thank you. At this time, I recognize Chairman of the full committee, Mr. Upton of Michigan, for 5 minutes.
Well, thank you, Mr. Chairman. Let's be honest. Under this administration's EPA, the extreme has become routine, and that's why when video surfaced of Dr. Armendariz talking about his crucify enforcement strategy, it really rang a bell with those of us in Congress who oversee the agency, not to mention those who have to deal with the economic consequences back home. His words provided a window into a pervasive mindset driving a long list of problematic enforcement and regulatory actions by the agency. To understand that mindset, we sought to hear from him directly. In fact, earlier this week, he confirmed that his testimony would arrive on time on Sunday. He volunteered to come. After all, it was his comments that so clearly embodied the hostile enforcement policy that we've seen in action for the last couple of years. And unfortunately, late yesterday afternoon, very late yesterday afternoon, an attorney representing him contacted the committee staff to notify us that despite his earlier agreement to come, he was no longer willing to testify. Well, we'd like to know why. And why several weeks after he agreed to testify did he retain counsel and then withdraw? Did the EPA, did they interfere with this witness? We don't know. But I have in my hand a couple copies of letters that we intend to send today to the EPA and to Dr. Armendariz to ask those questions. Congress and the American people deserve answers about the administration's policies and practices, and we intend to get them. But even without his appearance today, we are going to scrutinize the agency's actions by hearing directly from those on the receiving end of their enforcement. Over and over, we've seen EPA treating job-creating energy companies as if they were the enemy. We've seen new regulations that defy any credible reading of the authority delegated at the agency. EPA's attitude towards the private sector is troublesome enough, but its treatment of non-federal levels of government is hardly any better. And I would remind everyone that the very first section of the Clean Air Act states that air pollution control at its source is the primary responsibility of states and local governments. Today we're going to hear from those state, local, and tribal officials whose long-standing working relationship with the federal EPA has deteriorated considerably under this administration. The Clean Air Act has effectively balanced economic growth and environmental improvement for decades, and I'm concerned that the EPA has gotten far away from that balance. I yield my time now to Mr. Barton.
Thank you, Chairman. Thank you, Chairman Whitfield and Ranking Member Rush, for holding this hearing. I, like Chairman Upton, am disappointed but not surprised that former Regional Administrator Armendariz has chosen not to testify before this subcommittee. As my friend Mr. Green just pointed out, at a field hearing down in Houston, the former Regional Administrator was blocks away, was formally invited to testify, participate at that hearing, and again chose not to do so. The Congress sets the rules and the administration enforces them. We have a good set of environmental laws on the books. We expect President Obama and his appointees to enforce those rules in an even and fair-handed fashion. In the case of Region 6 Administrator Armendariz, he was not a fair umpire. He had a preconceived mindset, viewed himself more as an executioner than as a fair umpire, as some of his comments have shown. As soon as he became the Region 6 Administrator, EPA withdrew a long-standing support of Texas Flexible Air Permit Program that was initiated under President Clinton. The Obama administration, through Administrator Armendariz, removed that. In the cases of Range Resources, which dealt with the issue of hydraulic fracturing, again, former Regional Administrator Armendariz came into office saying that he wanted to eliminate hydraulic fracturing. He thought he had the case in Range Resources and moved to an enforcement action, even when the then chairman of the Railroad Commission of Texas sent him an email saying that that was premature and that the facts did not justify that. In Idaho, just recently, the Obama administration went against a family called the Sackett's on a wetlands issue. Again, Mr. Chairman, the Congress sets the rules and the administration enforces them. This Obama administration, in the case of the EPA, doesn't want to play by the rules. They want to set their own rules and then in some cases literally try to put industries and businesses out of business. With that, I yield to my good friend from Denton County, Dr. Burgess.
Out of time. This time I recognize the gentleman from California, Mr. Waxman, for 5 minutes.
Thank you, Mr. Chairman. In May 2010, then EPA Regional Administrator Al Armendariz was in Dish, Texas, talking to citizens concerned about oil and gas pollution. When he started describing his philosophy of enforcement, he used a poor analogy involving Romans and crucifixion. Everyone agrees that it was an inappropriate comment. But those who oppose strong enforcement of the nation's environmental laws have exaggerated what was said in order to make absurd attacks on EPA and the Obama administration. They claimed that Dr. Armendariz intended to take enforcement actions against innocent companies and that his comments are representative of EPA's overall enforcement philosophy. This smear attack ignores most of what Dr. Armendariz said that day, and it ignores the facts. Dr. Armendariz has apologized for his controversial comments, and he has resigned. He has made it very clear that those comments were an inaccurate way to describe EPA's enforcement efforts. And it is important to realize that no enforcement action has been taken in Dish, Texas. EPA Administrator Lisa Jackson and the White House have reiterated that the comments do not reflect any EPA policies or the agency's actions. Despite these clear statements, EPA's critics claim that the controversial Armendariz comments must represent EPA's true enforcement policy. This is just more of the same fact-free, anti-EPA rhetoric from the Republicans. Here are the facts. The Clean Air Act, Clean Water Act, Safe Drinking Water Act, and other cornerstone environmental laws allow states to implement and administer the statute's requirements. It's EPA's job to ensure that the states implement nationally consistent programs that meet federal standards. The states do not always meet these expectations. In fact, EPA IG recently found that, quote, state enforcement programs frequently do not meet national goals and states do not always take necessary enforcement actions. State enforcement programs are underperforming, non-compliance is high, and the level of enforcement is low, end quote. And in these situations, EPA has the authority to step in to take the action needed to enforce the law. For decades, the enforcement decisions have been made by career EPA enforcement professionals, not political appointees. That has not changed under this administration. Since the agency was formed during the Nixon administration, EPA has employed a philosophy of deterrence. EPA punishes violations of the law fairly and openly in order to deter others from breaking the law. And EPA focuses its limited enforcement resources on the highest priorities that represent the most serious pollution problems. There's nothing unique about this approach. In fact, I would be surprised if we could find a well-run law enforcement agency or civil enforcement program in the country that worked differently. The data tells the story. I have charts, and this first chart shows that the number of EPA enforcement actions nationwide over the last 11 years. As you can see, the number of enforcement actions during the first 3 years of the Obama administration has actually dropped off slightly compared with the Bush administration years. I see no evidence of an overzealous enforcement policy here. Let's look at just EPA Region 6. That's the region that Dr. Armendariz led. If his controversial remarks reflected a radical enforcement policy, then surely we would find evidence that in Region 6, but as you can see from the chart, that's simply not the case. Again, the number of civil enforcement actions is actually lower during the past 3 years than during the Bush years. The third chart shows that total civil penalties collected under the Obama administration are not much different than under the previous administration. You can see that the totals go up and down each year depending on when bigger cases are resolved. In fact, the average amount of civil penalties collected during the Bush administration is actually slightly higher than so far under the Obama administration. These are the facts. One comment from 2 years ago cannot change the facts. Environmental laws that protect our air and water are important to the health and well-being of Americans. The only way to ensure these protections are real is to enforce them. Career employees at EPA have been doing that enforcement work for 40 years, and they should keep doing so to protect American families from toxic chemicals and other pollutants. Thank you, Mr. Chairman.
Thank you. That concludes the opening statements today. So I want to welcome once again the first panel, the only panel. And on our panel today, we have with us Mr. Brian Shaw, who is chairman of the Texas Commission on Environmental Quality. We have Barry Smitherman, who's chairman of the Texas Railroad Commission. We have Mr. Robert Sullivan, who's chairman of the Oklahoma Independent Petroleum Association. We have Dr. Joel Mintz, who's a professor of law at Nova Scotia University. We have Mr. Stephen Etzedy, who's the executive director of the Navajo Nation Environmental Protection Agency. And we have Mr. Alan Short, who's the general manager of the Modesto Irrigation District in California. So welcome. We look forward to all of your testimony, and because you all are the ones that work on a daily basis with the federal EPA, and we look forward to your insights and comments. So, Chairman Smitherman, we'll call on you first for a 5-minute opening statement.
Thank you, Mr. Chairman, Mr. Vice Chairman, members of the committee, especially my friends from Texas. I am Barry Smitherman. I'm the chairman of the Texas Railroad Commission. Thank you for the opportunity to provide my perspective on the enforcement priorities and practices of the Environmental Protection Agency. As the chairman of the Railroad Commission, I and my Railroad Commission colleagues are responsible for overseeing the exploration and production of oil, natural gas, and lignite coal in Texas. Texas is the nation's largest producer of oil and natural gas, producing 413 million barrels of oil and 7.4 trillion cubic feet of natural gas in 2011. That translates into 1.1 million barrels of oil a day and about 20 BCF of natural gas a day. These numbers continue to increase in 2012. In March, we were producing 1.35 million barrels of crude oil a day. That is more than the United States presently imports from Venezuela. We're also the home of 49% of all the land-based rigs in America. This energy production supports 2 million jobs in Texas and is responsible for a quarter of the state's economy. The average oil and gas job in Texas pays about twice what the average non-oil and gas job pays. And these jobs, of course, are vital to the state's economic well-being as we continue to be a leader in energy production. The Railroad Commission, Mr. Chairman, has effectively regulated the energy industry in Texas since 1919. The state has maintained a predictable regulatory environment allowing for prolific yet responsible development, and this successful track record is partially due to the scientists, engineers, and policymakers that are closest to the variables being regulated, and they're most familiar with all the elements at play. State regulation of these industries is critical because, in my estimation, it is impossible for blanket federal regulations to account for the unique circumstances of each state. As has been highlighted several times earlier this morning, recently the EPA has been insinuating itself into areas that have historically been the purview of the states. Let me talk more about the Range Resources case which was mentioned. On December the 7th, 2010, the EPA issued an emergency order against Range Resources for allegedly contaminating a residential water well near Fort Worth. This order was issued despite the fact that the Railroad Commission staff had already advised the EPA that the Commission's investigation was ongoing and that no final conclusions had been reached. Furthermore, we now know that the EPA issued the order even though the EPA did not evaluate the underground geology in the area, did no research to determine possible pathways for the migration of the methane, and was in disagreement with many scientists. The Commission had already secured the voluntary cooperation from the operator, and we were moving quickly to investigate the situation. The Commission concluded in March of 2011 that Range Resources fracking activities were not responsible for the contamination of well water. However, the EPA continued with its investigation for another 12 months. Range Resources was forced to spend over $4 million defending itself against unfounded and unprecedented attacks. And then in March of 2012, in a one-paragraph letter, the EPA dropped its emergency endangerment order against the company. Unfortunately, Mr. Chairman, this is not an isolated incident. We've seen cases in Pavilion, Wyoming, and in Dimock, Pennsylvania, where the EPA has also accused oil and gas operators of groundwater contamination from fracking without sufficient evidence to justify those accusations. I hope, Mr. Chairman, that the result of this hearing today is that EPA will begin to listen and work with local regulators going forward, regulators that know best the circumstances, the underground geology, and the facts present in those states. Thank you very much.
Thank you, Mr. Smitherman. At this time, Mr. Shaw, you're recognized for 5 minutes.
Thank you. Good morning, Chairman Whitfield, Ranking Member Rush. I am Dr. Brian Shaw, the Chairman of the Texas Commission on Environmental Quality, and I appreciate the opportunity to visit with you today about many issues ongoing with the relationship between EPA and specifically the state of Texas. I am not interested and not here specifically to pile on to Dr. Armendariz and his time as Region 6 Administrator. Instead, I think it's important that we recognize the pattern and the philosophy that his comments represented that seem to be consistent with what we've seen through recent EPA actions, specifically the enforcement activity as well as regulation, and not just suggesting that the number of regulations or enforcement cases rather went up, but the failure to have a just and reasonable and fair regulatory process and enforcement policy, which is demonstrated not only in the examples that you've heard cited today, but also what we've seen in other rulemaking, such as the Flexible Permits Program, which you discussed earlier, whereby EPA did not apply science and the law to overturn Texas program, but instead wishes to impose what they desire short of the Clean Air Act and federal regulations. And to that end, Dr. Armendariz, after Texas having gone through the process of trying to explain how the Flexible Permits Program did indeed meet the requirements of the Clean Air Act and met those that they published, the concerns that they published in the Federal Register, the response that he said, I believe Gina McCarthy was in the room at the time, was that EPA was not interested and did not want to have a flexible permit program. A very similar type philosophy in that EPA was not interested in making sure that the state program met federal requirements or even that we were achieving our environmental goals, but instead in wanting to make sure that their politically driven policies were in place. And that's why I'm here today is hoping that we can, as Chairman Smitherman talked, encourage EPA to work with us as partners to recognize that relationship that we should have between state and federal government, so that we can follow what our goal at TCEQ is, to have sensible regulations that address real environmental risk while encouraging economic growth. We do that with regulations that are based on science and compliance with state and federal statutes. And in every case that we disagree with EPA and have lawsuits on many of those, it's because of their actions not being consistent with that principle of sound science, reasonable approach where we follow the law and common sense applied to that. I mentioned the Flexible Permits Program as a prime example of their failure to follow that process, and in fact, Dr. Armendariz was one of the key leaders in unraveling that program, which was in place for 15 years, which was one that led to numerous environmental benefits. And when asked to produce a single instance where the Flexible Permits Program demonstrated a failure to follow federal law or even to reduce the requirement to reduce those emissions, that did not occur. EPA stood by their desire, not the demonstration of any concerns within the Federal Register or Clean Air Act, that the program didn't meet federal requirements, but instead they didn't want the Flexible Permit Program. As a result, 65 flexible permits in Texas have been deflexed, the term that we've used, and EPA basically uses that to refer to those that have SIP-approved permits. There's 36 permit applications that are pending in-house, and we have 19 additional flex permit holders that have made commitments to deflex, but their applications are still pending. The deflex process has been an incredible waste of money and resources for both the permit holders and the environmental agency, with no environmental benefit. To be clear, no environmental benefit. To date, not one deflecting permit action has revealed the circumvention and emissions violation that EPA claimed were being hidden by those flexible permits. No additional emission limitations, additional controls required, or additional conditions have been added to any of those permits as a result of EPA's actions. I'd like next to move to another example of this failure to follow the common practice and the rules and regulations in place. It's our UIC, Underground Injection Control Program, as it relates to uranium mining, and EPA has deviated from what has been a 30-year practice of complying largely with their requirement that's mandated in federal statutes that they approve or deny within 90 days of submission of requests for aquifer exemption to allow in situ uranium mining. We have two cases whereby EPA has created two new requirements, modeling requirements that are not captured in the statutes, nor are they captured in EPA's guidance documents. We submitted letters to EPA recommending approval of those aquifers for exemption. They sent back letters requesting modeling, which is something that has never been required. They want modeling for 75 years life and to demonstrate that no drinking water will be impacted, and yet they can't demonstrate where our approved program has ever led to failure in the drinking water process. So I'm hopeful that we can find and move toward a more productive relationship with EPA. Thank you.
Thank you. Mr. Sullivan, you're recognized for 5 minutes. Be sure and turn your microphone on.
There we go. Thank you, Chairman Whitfield, Ranking Member Rush, and other members of the subcommittee. I very much appreciate this opportunity. I would like to also thank my Congressman Vice Chairman Sullivan for his leadership on crude oil and natural gas issues. And for the record, although I share his last name, we are not related, a fact for which I am sure Congressman Sullivan is continually grateful. I am chairman of the Oklahoma Independent Petroleum Association and the owner of Sullivan & Company, LLC, a 54-year-old family-owned independent producer of crude oil and natural gas. I have 25 employees, roughly half in the field and half in the office. Like my peer OIPA members, Sullivan & Company explores for new domestic oil and natural gas reserves using modern finding, drilling, and production techniques. In addition to our work on private lands, Sullivan & Company operates extensively on Indian lands. I have submitted my written testimony for the record and will take only a few minutes to address a few key points. First, the personal agendas of EPA officials impact EPA priorities and practices and result in overzealous enforcement actions. Wrongful EPA actions in the Parker County, Texas, Pavilion, Wyoming, and Dimmock, Pennsylvania instances show the limits of federal credibility when it comes to regulating oil and gas operations. We are troubled by the enforcement philosophy of EPA as expressed by Mr. Armendariz, but we are not surprised. Mr. Armendariz is a highly motivated environmental activist who pursued his anti-fossil fuel agenda through a powerful EPA post. He used the bogeyman of hydraulic fracturing, a safe and proven technology, to achieve his goals. With no scientific basis to fault hydraulic fracturing, activists and administration officials have become fearmongers. Their strategy is to create anxiety over oil and natural gas development, criticize state groundwater and drinking water protections as insufficient, federalize oil and gas regulations, and use that process to slow development by increasing the costs of regulatory compliance. Federalizing exploration and production rules will kill jobs, curb domestic energy production, and harm America. The federal government has neither the expertise nor the objectivity to fulfill such a charge. The regulation of oil and gas activities must reside with the states. Every state is geologically distinct. There is no one-size-fits-all solution or protection program. Second, the victims of corrupted EPA practices and science are policymakers of both major parties. Consumers and small oil and natural gas businesses like mine, nationwide, that's 18,000 companies, averaging about a dozen employees each and operating in 32 states. We independent producers have no refining or gasoline station operations. We sell our commodities, which are crude oil and natural gas, at whatever price the global market says they're worth. We are not big oil. But together, we independent producers drill 95% of all the wells in the United States and account for 68% of the total U.S. production. That's made up of roughly 82% of U.S. natural gas production and more than 54% of domestic oil production. Onshore in America, we independents are responsible for over 3% of the total U.S. workforce, more than 4 million American jobs, more than $579 billion in total economic activity, and 4% of the U.S. GDP. And we pay a lot of taxes, royalties, rents, and to federal, state, and local governments. In 2010, independent producers generated $131 billion for federal and state coffers. For every $1 million of upstream capital expenditures by independent producers, that results in $5.1 million in overall contribution to the U.S. GDP, in 6 direct jobs and 33 total upstream jobs. So there's 5-to-1 leverage there. For each of the past 4 years, the President has asked Congress to prevent small producers like me from deducting normal business expenses at tax time. He and his executive agencies have also rejected the Keystone XL pipeline, which independent producers need to move more oil more efficiently to market from Montana and North Dakota. They have opted for expanded new source performance and emission standards and mandatory greenhouse gas reporting rules that will cost our industry hundreds of millions of dollars. They have proposed a set of duplicative and unnecessary federal rules for hydraulic fracturing on public and Indian lands that will delay permits and reduce royalty payments to tribes and federal government. They have pressed for landmark legislation to raise the price of all fossil fuels in order to help create a market for alternative energy sources that do not exist in commercial volumes or are not economically feasible today. Finally, recent abuses by the EPA clearly show that Congress must exercise more oversight of the agency. Regional EPA administrators have too much power and at the very least should be subject to Senate confirmation. I thank you for the privilege of testifying, Mr. Chairman.
Well, thank you. And Dr. Mintz, when I introduced you, I made the mistake of saying Nova Scotia University, and it's Nova Southeastern University, where you're a professor of law. So you're recognized for 5 minutes.
Thank you, sir. Hey, we're a distance from Nova Scotia, actually. Not a problem. Mr. Chairman, Mr. Ranking Member, and members of the subcommittee, my name is Joel A. Mintz. I'm a professor of law at Nova Southeastern University in Fort Lauderdale, Florida. Since 1983, a major focus of my academic research and writing has been the enforcement work of EPA. I've written 3 books and a number of book chapters and law review articles that touch on EPA enforcement. My most recent book, Enforcement at the EPA, High Stakes and Hard Choices, Revised Edition, which I actually have a copy of here for purposes of shameless self-promotion, was published in April by the University of Texas Press. That work, based on 190 personal interviews with government enforcement officials as well as extensive documentary research, recounts the history of EPA's enforcement program from its beginnings in the early 1970s through January 2009. Since 2009, I've also conducted a number of informal telephone interviews with enforcement personnel at EPA and the Department of Justice to get a continuing sense of the major EPA enforcement developments and trends during the Obama administration. My testimony before you today is intended to put the enforcement work of EPA during the Obama administration to date into context and historical perspective, rather than to discuss any individual cases or regulations. My main point is simple and straightforward. For the past 3.5 years, EPA's approach to enforcement has employed the same overall philosophy and strategy that have characterized EPA enforcement since the early 1970s. Rather than being uniquely overzealous or draconian, EPA enforcement in the Obama years has followed long-standing patterns established at EPA well before 2009. From the agency's beginnings in the Nixon administration to the present day, EPA enforcement, with only a few brief periods of exception, has been based on a theory of deterrence. Under this deterrence theory, which is scarcely unique to EPA, violations of the law are to be detected promptly and fairly and appropriately punished as a way of deterring the individual violator and others similarly situated from violating the law in the future. The theory assumes that individuals and firms are rational economic actors who will comply with the law when the probability of detection is great enough and the penalties are high enough that it becomes economically irrational for them to violate the law. Of course, the constitutional rights of all citizens must be strictly protected during this process, both because it's the right thing to do and because enforcement cases will not succeed in the courts where citizens' rights are violated. Throughout EPA's history, with only minor exceptions, decisions regarding which industries and companies should be the focus of enforcement actions and whether those actions should be administrative, civil, judicial, or criminal in nature have been made by career enforcement professionals and not by political appointees. From the George H.W. Bush administration through the Obama administration to date, for approximately a third of its enforcement work, EPA's enforcement staff has relied on a national priority approach that targets particular industries and national or international firms for intensive, comprehensive enforcement actions. This targeting approach is a neutral, non-political procedure that employs statistical analysis of data to give enforcement priority to industries and firms which have the worst compliance records and whose environmental releases do the most harm to the health of Americans. EPA's own annual enforcement reports provide statistical evidence that EPA enforcement under Obama has not been uniquely harsh. They reveal, for example, that during the 8 years of the George W. Bush administration, the civil penalties assessed against environmental law violators averaged $117 million per year. In contrast, during the first 3 years of the Obama administration, EPA enforcement resulted in assessment of a slightly lower average amount of civil penalties, $115 million a year. Similarly, EPA enforcement actions against the oil and gas industry declined during the Obama administration as compared with the preceding presidency. EPA brought only 87 enforcement actions against the industry in 2011, while it initiated 224 such actions in 2002. Although there may well be good explanations for these declines, they do support the overall conclusions of my historical research. EPA's enforcement work during the Obama period has been similar in nature to the work it did in nearly every administration since the agency was established, regardless of the party affiliation of the president. Thank you.
Thank you, Dr. Mintz. Mr. Etzedy, you're recognized for 5 minutes.
Good morning, Chairman Whitfield, Ranking Member Rush, members of the committee. On behalf of Navajo Nation President Ben Shelley, we extend our appreciation for the opportunity to present our views this morning. I will focus on EPA's tribal consultation responsibilities and the regional Hays Rule BART determination processes and our experiences working with Region 6 and EPA headquarters. The Navajo Nation is a coal-based resource tribe with 2 large coal-fired power plants and associated mines on our lands and the 1,800 megawatt San Juan generating station and San Juan mine located just off the reservation in New Mexico. Both the San Juan plant and the San Juan mine are located outside the jurisdiction of the Navajo Nation, but the plant and the mine have a positive economic impact on the nation and on the regional economy. Because of the nation's substantial coal reserves and jobs in the energy sector, the regional Hays Rule and other EPA rules will have long-reaching impacts on the nation's sovereignty, including our ability to independently develop our natural resource economy and provide economic security for our tribal members. Recent rulemaking under the Regional Hays Rule by EPA imposed excessively stringent and expensive BART, or Selective Catalytic Reduction Control technology, on the San Juan plant and jeopardizes the continued viability of the power plant. In this regard, the EPA has a requirement to engage in meaningful consultation with the Navajo Nation in the development of regulations with tribal implications as recognized in Executive Order 13175
and EPA's tribal consultation policy, Section 4. However, EPA has failed to do so. The standard for determining whether a regulation has tribal implications is whether a proposed regulation has, quote, substantial direct effects on one or more Indian tribes. The federal implementation plan for the San Juan plant will have substantial direct effects on the Navajo Nation, the San Juan plant, San Juan mine, subcontractors, and seasonal workers. As the nation stated in its comments on the proposed FIP for San Juan, EPA provides a facile conclusion that it does not have direct tribal implications. Because the FIP does not impose federally enforceable emission limits on any source located on tribal lands, and neither imposes substantial direct compliance cost on the tribal government, nor preempts a tribal law. However, the EPA failed to consider potential regional economic impacts and impacts on the local Indian tribes, including the Navajo Nation, and the inevitable impacts if San Juan Generating Station and its mine were forced to close as a result of the imposition of costly SCR technology. EPA failed to conduct an accurate analysis of the potential social costs to the Navajo people. Should this final FIP result in closure of the San Juan plant and mine, hundreds of jobs will be lost, not only in the coal and power industry on the nation, but in the service support industry and public sector as well. A conservative estimate is that 318 Navajo jobs would be lost. This includes highly paid jobs that are about 2.7 times the average Navajo Nation household income of $20,000. This lost revenue would reduce spending by about $25 million per year and a loss of nearly $1 million annually in sales tax receipts. An increase in the number of unemployed on the Navajo Nation caused by the closure of the San Juan plant or the San Juan mine would result in increased demands in social services provided by the Navajo Nation and other government agencies. At a time when other EPA rulemakings are threatening to diminish the nation's coffers, such as BART determinations at the Four Corners Power Plant and the Navajo Generating Station, which are located on the reservation, these increased demands for services would necessitate that the Navajo Nation divert an increased percentage of its already stressed budget to provide for the social needs of the unemployed. This would divert funding that could be spent on economic development and thereby stunt future economic growth on the Navajo Nation. The nation supports the substantive goals of the Clean Air Act and the goal of the Regional Haze Rule to provide visibility or to improve visibility in Class 1 areas. However, implementation by EPA of the Regional Haze Rule and the BART process must be done with due analysis and accommodation of the critical economic interests of the Navajo Nation and the Navajo people in the continued operation of power plants in and near Navajo Indian country. EPA has an obligation, a requirement to meaningfully consult with the nation for rulemakings directly affecting the nation before proposing a draft rule and after promulgating a final rule. That was not done for the proposed FIP for San Juan or for the advance notice proposed rulemaking for the Four Corners Power Plant and the Navajo Generating Station, and EPA therefore violated its consultation obligations and responsibilities to the nation. The nation, nonetheless, remains hopeful that EPA will continue to improve its consultation practices in accordance with their own stated policies and to complete tribal consultation on the San Juan FIP and to work with EPA in a true government-to-government relationship. Thank you.
Thank you very much. Mr. Short, you're recognized for 5 minutes.
Thank you, Mr. Chairman, and Ranking Member Rush, and members of the Subcommittee on Energy and Power. Good morning. My name is Alan Short. I'm the General Manager of the Modesto Irrigation District, located in California's Central Valley. Thank you for the opportunity to speak with you about EPA's enforcement as what you've just heard, the Regional Haze Rule at the San Juan Generating Station. Coal-fired plant, as you now know, is located in New Mexico, specifically in EPA Region 6. I am here because the San Juan Station is a significant source of power for hundreds of thousands of customers throughout California. Modesto Irrigation District is a local, publicly owned utility that is in partnership with the City of Santa Clara, the City of Redding, which form the MSR Joint Power Agency. We serve roughly 210,000 customers in California, and the MSR owns a mix of generating resources, including a share of the Generation Station Unit 4, which provides 150 megawatts to MSR members. The station is also an important source of electricity for the Southern California Public Power Authority, SCAPA, whose members serve almost 5 million customers. SCAPA members own a part of San Juan as well. Collectively, California Public Utilities own 24.5% of the San Juan station. The principal owner and operator of the San Juan station is Public Service Company of New Mexico, PNM, and an investor-owned utility. My testimony is on behalf of MID, MSR, and SCAPA. Under the Clean Air Act regional haze provision, each state and EPA are required to develop and implement plans to help restore natural visibility at 156 national parks and wilderness areas by the year 2064. To comply, the state of New Mexico proposed a plan for the generation facility that would meet the goals and objectives of the rule with an emissions technology which would cost approximately $77 million. Unfortunately, EPA rejected the state plan for the San Juan generation station and has established a federal plan that requires installation of emissions control technology costing somewhere between $750 and $805 million. And this is based upon installation bids from firms specializing in this technology. The bids are more than twice EPA's cost estimate of $345 million. Although EPA's approach would cost 10 times more than the state plan, it would remove only slightly more haze, an improvement that would be virtually imperceptible to the human eye. It is important to understand the regional haze standards are not health-based standards. They are about visibility only. This is why cost-effectiveness and reasonableness are the main factors for selecting the regional haze emissions technology. By grossly underestimating the real cost of its plan, EPA also overstates the cost-effectiveness. MSR and SCAPA share of cost for EPA plan to its customers will range from $272 to $2,250 per year. This is also on top of the many stringent mandates that California has imposed upon electric utilities. Environmental organizations want the federal plan to be implemented on a timetable that would require shutting down all or parts of the station during installation and could affect the reliability of the regional transmission grid. Environmental groups have also asked the California Energy Commission to prevent MSR and SCAPA from paying for regional haze compliance at San Juan. San Juan owners must begin the federal plan immediately. New Mexico Governor Susana Martinez has asked EPA to stay implementation of the plan so that the state and EPA and PNM can work towards an agreeable alternative to the state and federal plans. We strongly support the governor's effort to sit down and talk with EPA. California public utilities are willing to do their share to reduce regional haze through a cost-effective and reasonable improvements to the station. But our customers should not have to pay for the extreme costly technologies that produce only marginal benefits as compared to similarly effective alternatives. Again, this falls down to the customer who will actually pay for it and will have an effect on the California economy, jobs, and home foreclosures. Thank you.
Well, thank you, and thank all of you for your testimony. I really wish we had maybe a full day for this hearing because there are so many issues here. And one thing that all of us recognize that when you deal with EPA regulations and enforcement actions, it's very complex and it's not easy to discuss in a readily comprehensible way. Now, of the people on this first panel, how many of you have worked as a part of the responsibility of the job you have worked closely with Region 6 on issues affecting you in one way or the other? Would you raise your hand if you've worked quite frequently with Region 6? Okay. Everyone raised their hand except Dr. Mintz. Now, when I go to Kentucky and I talk to farmers and I talk to coal miners and I talk to natural gas producers, they tell me that they genuinely believe that there is a bias against fossil fuel at EPA. So for those of you who have worked with them on a regular basis, would you tell me your personal belief? Do you believe, honestly, that there is a bias against fossil fuel within the Region 6 EPA? Mr. Zimmerman.
Mr. Chairman, I do believe there's a bias. I think it's reflected in the onslaught of regulations we've seen coming out of this administration, first directed at coal. Effectively now you cannot build a new coal plant in America, and now more increasingly directed against oil and natural gas.
Okay. Mr. Shaw.
Yes, Chairman, thank you. I do believe there is a bias. It's demonstrated not only in the enforcement action we've talked about today, but many of the regulatory actions that have been coming forth, which EPA seems to go to great lengths to attempt to justify outside of the normal process without following their own rules and regulations. And quite frankly, it follows the examples we talked about with Dr. Armendariz' comments and others on EPA's philosophy.
Mr. Sullivan.
Yes, Mr. Chairman, I do think there's a bias, and I think it comes from the top. Whenever you have a president once a week out there hammering against fossil fuels, it's natural for those in the various agencies to be very aggressive in promulgating that. And I definitely see a bias in their actions and in their words.
Mr. Etzedy.
Thank you for the question, Mr. Chairman. I believe there is a difference. I wouldn't characterize it as a bias, and I would compare our work with EPA under other offices other than the Office of Air and Radiation, especially when we talk about our consultation processes. We've had successful consultation and worked on many issues with EPA, Region 6 and Region 9, but under the Clean Air Act issues, it's been very difficult.
So it's been different under the Clean Air Act
Yes.
issues. And I think you made the statement that they were not following their consultation obligations under the Clean Air Act.
That's correct.
Okay. Mr. Short.
Thank you, Mr. Chairman. I would say that there certainly is a preference towards natural gas versus coal when dealing with EPA Region 6. But let me just say from that perspective, you guys have great jobs in producing legislation. The EPA regulates, and my job is to comply as best I can with the best technology and at the most cost-effective and reasonable approach. So even though there may be a preference towards natural gas, I still need to deal in the world that is given to me today, which is I've got to comply.
And you import electricity from New Mexico, the Four Corners Generating Station and San Juan Station. Do you import electricity from those areas?
That is correct. We bring electricity in from the Four Corners area, as does SCAPA. It comes in through lines that we own with our friends and our partners, and then it comes all the way up the Central Valley into Modesto and then over to Santa Clara and up to Redding.
And there is no question in your mind that EPA and environmental groups are trying to require that you not buy electricity produced from coal in New Mexico. Is that correct?
Yeah, there's a law in California, it's called 1368, which really prohibits the investment in new coal-fired facilities and also prohibits the investment in upgrading existing coal-fired facilities to extend the life of those facilities. So there is a move to eliminate coal in California.
And you said that all of this really comes from the effort to reduce regional haze in that area. Is that correct?
Well, California has a different set of rules. They established that they established that over the last couple of years in preventing coal from coming into California, or coal-fired electricity from coming into California. The regional haze issue is another concern that we have, which is layered on top of the California mandates.
And every time, we've had lots of hearings with EPA, and every time they come up here, on every regulation, they talk about the necessity for these regulations because of health. Now, you've said that in the regional haze issue that health has nothing to do with that. Is that correct?
It's a visibility issue, not a health issue.
Okay. Okay. Well, my time has expired. Thank you very much. This time I recognize the gentleman from Illinois, Mr. Rush, for 5 minutes.
I want to thank you, Mr. Chairman. Well, Mr. Chairman, you asked the question of how many of the witnesses have been who have worked personally with the EPA. I would like to ask the witnesses, how many of the witnesses present at the witness table today were personally invited to testify at this hearing by the chairman or the chairman's staff?
I think we hold.
How many you, please raise your hands, how many were personally invited by the chairman or the chairman's staff to testify at the hearing today? Let me ask it again. How many of the witnesses were personally invited by the chairman, Mr. Whitfield, or the chairman's staff? All right, thank you. All right. Everybody. My point is that 5 of the 6 witnesses were invited, all of them were invited, but the fact that 5 of them are representatives of industry, that's the point that I'm trying to make. And that they were invited. Only 1 witness is a Democratic witness. Did you want more? And we would like to have had more, absolutely. All right. Now, the point, I want to ask Dr. Mintz. The Associated Press examined 10 years of data on the EPA's enforcement of noncompliance by oil and gas producers, and according to their independent analysis, the number of enforcement cases against oil and gas companies in Region 5 and also across the nation has been lower every year under the Obama administration than any year under the Bush administration. In fact, the EPA reported that nationally, the number of enforcement actions against oil and gas producers dropped by 61% over the last decade, from 224 in 2002 to 87 in the year 2011. And the EPA notes that this decline has occurred even though the number of wells has increased, and EPA has listed energy extraction as a priority enforcement area. Dr. Mintz, are you familiar with this AP analysis? And if so, would you concur with the findings of this independent and unaffiliated analysis?
Yes, sir, I'm familiar with it, and to my knowledge, it's correct. From what I understand, EPA's statistics actually cover a somewhat broader range than just the oil and gas industry, I've been informed, but nonetheless, it's, I think, substantially correct, and I have no reason to doubt their figures.
As you can see, Dr. Mintz, and as I tried to point out, there are no witnesses today from the public health sector. All industry witnesses today, 5 of the 6 are industry witnesses today. They're from industry, none from the public health sector. They're all from industry. As a former chief attorney with the U.S. Environmental Protection Agency here in Chicago, and here in Washington, I wonder if you might briefly speak about some of the health impacts associated with air and water pollution that EPA and the Clean Air Act were initially designed to address.
Certainly, sir. I don't pretend to be an expert in public health issues or epidemiology, but just as a matter of general knowledge from my work at EPA, I know that the Clean Air Act was aimed at preventing or lowering the incidence of lung diseases. They are related to a number of types of emissions of pollutants, for example, sulfur dioxide, small particulate matter, and other kinds of emissions that can have a health impact.
I want to thank you, and Mr. Chairman, I do have an open letter from 350 health professionals to policymakers in support of the Clean Air Act and the environmental, the EPA, that was submitted to my office, and I would like to submit both the AP report and also the open letter to policymakers. I would like to submit that for the record.
Well, without objection, and I might say Mr. Smitherman, Mr. Shaw, and Mr. Etzity have responsibility for health issues. I'm positive of that because you enforce the Clean Air Act under your state implementation plan. Okay, at this time, I recognize the gentleman from Texas, Mr. Barton.
Thank you, Mr. Chairman. A couple of editorial comments before I ask my questions. All witnesses are invited by the majority staff in consultation with the minority and the minority staff. And I think I wasn't involved in the witness decisions, but my understanding is that if the minority had wanted additional witnesses, I won't say they would have all been accommodated, but certainly an effort would have been made to accommodate some of them. And I know from personal interaction with Mr. Whitfield that he is very accommodating to members when they have specific requests. So,
Would the gentleman yield?
as long as it doesn't come out of my time.
Well, I don't want to take up your time, but I just want to note that we need to have, in one of these hearings, we need to have public health officials. And it would have been real good if we had invited public health officials.
You got Chairman.
Public health officials, not someone who have...
The chairman of the Texas Railroad Commission, the chairman of the Texas Council for Environmental Quality. I believe we have a chief from the Navajo Nation. I would think that, I believe we also, the gentleman from Oklahoma, has statewide responsibility. So to say that those do not represent public health would I think, be somewhat disingenuous. They have, that is their function, especially Texas Council on Environmental Quality. Its sole function is to protect the public health. They're appointed by the governor on the advice and consent of the Texas legislature, and I would assume similar in the Navajo Nation in the state of Oklahoma. So they represent.
I don't have the time, but if you would yield just another 2 seconds.
I hope that I have some really good questions, and I hope
all right.
restart.
I just want to say to my friend from Texas, you are a very accomplished man. I really respect you a lot. And you have a lot of responsibilities, and you're former chairman of this committee. But I would not want you to testify as a public health expert before this very committee. We need public health experts, not people who have some kind of tangential relationship with public health issues.
Mr. Chairman, I would ask unanimous consent that my clock be reset to 5 o'clock, 5 minutes.
Yeah, Mr. Rush insists that be the case. So.
Thank you. Mr. Smitherman, you are the chairman of the Texas Council on Environmental Quality. Mr. Shaw, you are the chairman of the Texas Council on Environmental Quality. Is that not correct?
That's correct. I'm the chairman of the Texas Commission on Environmental Quality.
All right. Is Texas air quality improving, about the same, getting worse?
It's improving and consistently and fairly dramatically improving.
When the President Obama and his regional administrator decided to throw out the Texas flexible permitting program several years ago, was that because there was statistical evidence that air quality in Texas was disintegrating?
No, sir. There were allegations that somehow the playing field was unlevel, that we were somehow achieving better in financial success because we weren't upholding the environmental rules, yet the data clearly showed we were making continual environmental improvement.
Mr. Smitherman, you are the chairman of the Texas Railroad Commission, is that correct?
That's correct, sir.
And your agency has regulatory authority over oil and gas operations in the state of Texas. Is that not correct?
Yes, we regulate oil and gas, lignite coal development. We protect correlative rights, and we have a mission to protect and prevent waste.
And under both federal and state law, it is your agency that would regulate the practice that is generally called hydraulic fracturing. Is that not correct?
That is correct. The fracking process, all of which happens underground, is overseen and monitored by our agency.
And when in December, well actually in August of 2010, a local homeowner in Parker County, a Mr. Lipinski, made a complaint to your agency that he had natural gas in his well water, and he asked your agency to investigate that. Is that not correct?
Yes, sir.
And within days, your agency sent experts to conduct that investigation. Is that not correct?
That's correct.
And your investigators forwarded their findings to the Regional 6 Office of EPA. Is that not correct?
Yes, sir.
And when the Regional 6 administrator decided to issue a press release, give a television interview, and render an emergency enforcement order against Range Resources, is it also not correct that your predecessor, Chairman Carrillo, sent an email to Mr. Armendariz saying that that was premature?
Correct.
And in spite of that, they went ahead and issued this enforcement order, emergency enforcement order.
In addition to that, former Chairman Barton, the language used by Mr. Armendariz said that houses could explode if they did not go forward with the enforcement order.
Now, as it turned out, as the Texas Railroad Commission conducted its investigation, they had a hearing and invited the EPA and the landowner, the homeowner, to participate, and it's my understanding that neither the EPA nor the homeowner participated in that hearing. Is that correct?
That's correct.
But in that hearing, evidence was presented that showed beyond a shadow of a doubt that the natural gas in the well water was not because of hydraulic fracturing. Now, I want to read a statement. This statement is from the pleading of Range Resources. So it is. I'm going to read it, and I want you to tell me if you agree that this is factually correct. And I quote, "The evidence in the record is overwhelming and conclusive. The Range gas wells and the Barnett Shale are not the source of the gas in the Lipinski or Haley water wells or in any other area water wells, and hydraulic fracturing and all other oil and gas activities have not in any way contributed to the contamination of fresh water in this area. All of the evidence, historic, geologic, microseismic, engineering, gas fingerprinting, and water well sampling establishes that the source of natural gas in the Lipinski well and in the other area water wells is not the Barnett Shale, but is shallow gas-bearing Strong Formation. The migration of natural gas from the Strong Formation to freshwater aquifers is not the result of oil and gas activities, but has occurred over decades through a regional natural geologic connection exacerbated by increased pumping from the aquifer and by water wells drilled into the Strong." Do you agree with that statement?
That's correct. That was the conclusion. The gas was naturally occurring. The fingerprinting of it did not match the gas being produced in the Barnett Shale.
My time has expired, Mr. Chairman, but what I want to state is we have strong environmental laws. We expect those laws to be enforced strongly. We expect them also to be enforced fairly. In this case, the Obama administration and the Region 6 Minister, Mr. Armendariz, had a preconceived conclusion to shut down hydraulic fracturing. They took this case, the Range Resources case, they thought they had the smoking gun. They found out they did not, and yet they continued in a public way to try to castigate hydraulic fracturing. That, to me, is inexcusable.
Gentleman's time has expired. At this time, I recognize the gentleman from Texas, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman. Following up my colleague and good friend from Texas, sometimes you have your preconceived conclusion, but the facts doesn't always get there. And a number of questions I won't get to, but for state regulators, we're all aware of how the EPA got ahead of itself in Parker County, Pavilion, Wyoming, and Dimmock, Pennsylvania. Are any of you aware of other instances, maybe not as notable, where the EPA seemed to get ahead of the data and issue a notice of violation or emergency order and just to retract it later?
Congressman Green, I would say these particular three cases have a fact pattern that is so similar that is why they are routinely identified as being egregious cases, and those are the ones that we focused on the most.
Okay. But if there's other examples, obviously, because these are three separate regions, by the way. It's not just Region 6, it's ours in Texas, but Pennsylvania, which has had some great success in producing natural gas from it.
But the Parker County one was the first, and the others followed behind that.
Any other from any of our state regulators? My next question is for the chair of the TCQ. Mrs. Shaw, in your opening statement, you mentioned that the AP analysis focused on EPA enforcement actions on upstream production. Have you noticed a noticeable trend in enforcement actions on downstream production?
Well, let me say, Congressman Green, first of all, because of the relationship I have, I'm not able to talk about enforcement actions within the state because they may involve me making an ultimate decision, and so I have to avoid that, but my staff would certainly be able to provide that type of information.
Okay, we'll ask that on the staff level. Also, I was frustrated when Texas was included in the cross-state air pollution role for sulfur dioxide and tried to work with EPA, and again, my colleague Joe Barton and I worked with EPA and to no avail, and then talking with management and budget, seeing the EPA many times before the rule. Even though Texas is not included in the proposed rule, once they obviously made the decision to include Texas, did they try to work with TECQ at all before the rule went final?
No, sir. And in fact, we made several requests for an opportunity to meet with either Ms. Jackson or other officials on that issue, and were unable to do so, primarily expressing concern that without opportunity to comment on that, they were moving forward with the rule. And in fact, they did move forward without allowing us to provide input that would have shined a different light on some of the data they used to make that determination.
Well, and one of the concerns I had about that was that a lot of their modeling, maybe, although originally most of us who looked at it, Texas wasn't included. But then much after all the discussion, all of a sudden we were, but it was modeling instead of actual on-the-ground facts.
That's correct. The reason they included and justified including Texas was based on updated data, which they didn't give us a chance to evaluate and point out some problems with the updated emissions data, as well as modeling to predict that Texas was going to contribute to a downwind monitor, which, by the way, is attaining the air quality standard. It is not projected to exceed the air quality standard, but nonetheless, they use that modeling to somehow tie Texas to that facility.
In my next question about flex permits, but I appreciate what TCQ. I probably have the most monitored district in the country.
Yes.
5 refineries and lots of chemical plants, both TCQ, EPA, my local Harris County Pollution Control Agency. The industry now, to their credit, is fence line monitoring because they don't want to get blamed for what their neighbors are doing because we have them literally fence to fence. So that's why there's data available. Yes. Instead of doing, you can actually get real-time data on whether we're contributing to Illinois and Indiana's pollution from Central and East Texas. But like I said, I come from an oil and gas area, not a coal area, so I'll let Joe Barton and his folks work on that. On the flex permit, EPA's disapproval of the Texas Flex Air Permit Program and how the deflexing process is going. I know I've worked with all my plants along the channel and was concerned because on any given day, we have such huge facilities. If they have a slowdown in getting permitting, you're going to shut production or slow production. Can you give us how the deflexing process is going? Because this is the first time in history.
Right, it's the first time, and it's moving along. We've had 65 facilities successfully deflex. The key component of that, Congressman, is that there have been no environmental benefits associated with that. It's been a great bureaucratic waste of time and effort. All that's occurred has been lots of time and money spent and some loss of flexibility for those facilities. Quite frankly, it was and should still be a program that's held up as innovative and creative in the way we ought to be relating to the industry to encourage and incentivize reduction.
Well, I know some of the concern is that Texas had huge numbers of these flex permits compared to our neighbors in Oklahoma. You give us a hole, we'll drive a truck through it. But it worked because the air quality had improved. And I understand the problem was they couldn't understand with the flex permitting, they couldn't, so they really want all the paperwork to add up, even though the results from the monitoring was still good and getting better.
In fact, the requirement to get a flexible permit was that they had to model a facility on worst case scenarios, and so effectively they were having to overcome an even greater burden so that the worst case operation would be protective, which is even more stringent than a typical permit requirement.
Mr. Chairman, I can't see the clock. Am I out of time or I have a couple seconds left?
Yeah, you've gone 30 seconds over.
Oh, I apologize. Let me just say, because the concern about underground injection, I know our wells, and I know the Railroad Commission does that. We'll submit a question to our chair of our Railroad Commission
Thank
for
you.
the committee.
This time I recognize the gentleman from Oklahoma, Mr. Sullivan, for 5 minutes.
Just got to get my glasses here. Thank you, Mr. Chairman. Mr. Sullivan, I'd like to ask you a couple questions. You stated in your testimony that the former Region 6 Administrator, Armendariz, met with your organization in 2010 and made it clear, quote, he intended to initiate an attack on oil and natural gas producers within Region 6. Could you tell us more about that meeting and why he gave the impression that he would be aggressive with the oil and natural gas producers?
Yes, you're referring to a meeting 2 years ago this week, actually, our annual meeting of the OIPA, and we invited him to come to present. And there are probably 600 Oklahoma producers at that meeting. How many of them attended the actual session he was involved in, I can't tell you, but I do know that when they came out of that room, there was concern because the theme of his remarks was there's a new sheriff in town and we're going to enforce oil and gas regulations with vigor. So that was the first straw in the wind that we had, frankly, and the attitude listening to him by our group was one of fear.
Wow. While he has resigned, do you continue to be concerned about the aggressive rhetoric and actions of the EPA from that meeting and going forward with what you've seen in some of the actions they've taken?
Well, I'm not here to pile on Mr. Armendariz's remarks, but in the context that it's indicative of an attitude and a messaging that's coming at us every day, I'm very concerned about it. And let me mention something that has not been mentioned in this hearing. One of the two biggest ingredients in our business are technology and capital. And capital comes towards any business or industry where it's invited. It flees where it's discouraged. And with this kind of error or threat, if you want to call it that, of overreaching by EPA into our industry, that capital can very easily go anywhere else. Last year, calendar 2011, I plowed back 130% of the cash flow from our little company. Well, how'd you do that? Well, I went outside and put all mine back on the table and went out and attracted some other capital. In sitting with those people who I'm asking to write checks to go drill wells for, they are reluctant to put money into an industry that has this kind of overreach, the cloud there. So when these messages are being sent, not just from Mr. Armendariz, but from the entire EPA experience where we deal with them along the way, it's very harmful to our company. As I testified, every dollar we put into the business, there's $5 of benefit. So anyway, that's the way I kind of measure it, is it scaring away money?
That's awful. Well, do concerns about EPA regulatory overreach impact economic growth? You've talked about that, job creation. And, one of the things one of the biggest complaints I get when I go around the district or Oklahoma or in the country for that matter, and it kind of underscores what you said, is that they say, what are you politicians going to do to create jobs? Unemployment's high, unacceptable levels. And the thing that we don't create jobs, politicians don't, but we can get out of the way. And regulations, some are very necessary, but there is an overreach out there right now. And it's keeping a lot of cash on the sidelines. The cash is not the problem. Capital formation's there. Their debt is cheap. There's a lot of private equity. Interest rates are low. But there's still a lot of money on the sidelines, like you were talking about, Mr. Sullivan. And this cash is not going to go to places that has so many barriers there and uncertainty. And that's what we can do to create jobs in America, especially in this industry, is if we can just get out of the way. And any regulations going forward should have some cost-benefit analysis and address how it affects job creation and global competitiveness and how fuel prices will go up and how it affects electric reliability. And so I think that your testimony is extremely important in this, and thank you so much.
Thank you, Mr. Sullivan. At this time, I recognize the gentleman from California, Mr. Waxman, for 5 minutes.
Thank you, Mr. Chairman. Dr. Armendariz is not here today. But he apologized for the comments he made 2 years ago in Dish, Texas, and he resigned. He also made it very clear that his comments were an inaccurate way to describe EPA's enforcement efforts. Critics of EPA claim that his comments provided, quote, a rare glimpse into the Obama administration's true agenda, end quote. They claim that EPA's general philosophy is to crucify and make examples of domestic energy producers so that other companies will fall in line with EPA's regulatory whims, end quote. They interpret his comments as proof that EPA is happy to take enforcement actions against companies regardless of whether they violated the law. Mr. Mintz, you're an expert on EPA enforcement. We're looking to you for a reality check. Who at EPA is making decisions about when to bring an enforcement action in specific cases? Are they decisions made by political appointees?
No, sir, not at all. They're generally made by career staff on a case-by-case basis.
Do EPA regional administrators dictate whether EPA takes a specific enforcement action?
Not typically, no.
We've heard claims that Dr. Armendariz' unfortunate remarks about crucifying oil and gas companies reflect the hidden agenda of the Obama administration. Mr. Mintz, based on your research on EPA enforcement, does the Obama administration's approach to enforcement differ significantly from past administrations?
No, it does not.
And the facts support that statement. According to nationwide enforcement data provided by EPA, the Obama EPA has taken fewer civil enforcement actions on average than the Bush administration. The same holds true for Region 6, which Dr. Armendariz led. The average amount of annual civil penalties across the country has not increased either. So that's the big picture. Let's take a couple of examples from this panel. Mr. Short, the regional haze issue you raised today isn't an enforcement issue, is it? This involves air rules and implementation plans, isn't that right?
That is correct. The state has the responsibility, along with EPA, to develop and implement a plan to address the regional haze piece.
And EPA issued a proposed rule on the state implementation plan a few days ago, indicating that the parties should discuss the issue to see if they can resolve it. Isn't that right?
Yes.
Mr. Etzity, are there areas where the Navajo Nation EPA has worked well with EPA? Are you supportive of their enforcement approach with regard to the remediation of abandoned uranium mines?
Thank you for the question. Yes, we have had good working relationships with EPA Region 9 and Region 6 addressing the problem of abandoned uranium mines and the cleanup necessary.
Well, Dr. Armendariz's poor choice of words did not represent some sinister, previously undisclosed EPA enforcement policy or philosophy. Frankly, the absurdity of the anti-EPA rhetoric coming from the other side of the aisle and from some industry groups is stunning. These extreme accusations are completely divorced from reality. EPA should be enforcing the laws on the books. That is common sense. Career professionals have been doing that important work for the last 40 years. Congress should be supporting their efforts, not attacking them with fact-free rhetoric. Thank you, Mr. Chairman. I yield back to the Council.
This time I recognize the gentleman from Texas, Dr. Burgess, for 5 minutes.
Thank you, Mr. Chairman, for the recognition. I want to thank our witnesses for being here today. It is a shame that Dr. Armendariz could not be here. It would have been good to get his perspective on things. He obviously said the things he said that night in my district because the concern of the people on the ground in Dish, Texas, about what they saw happening in their community. And Dr. Armendariz went there because of that concern that had been expressed to him by the mayor and other people in the town. I'm just absolutely stunned and puzzled by Mr. Waxman's comments, where he says that Dr. Armendariz did not result in any additional enforcement action. So, I mean, what was accomplished? He got some headlines. He lost his job, but he got the attention that I guess he sought. But what about the long-suffering people of Dish, Texas? Did they get any remediation for the problems that they sought, for which they sought a solution? And what did happen, and I will just tell you this as a consequence of that night, the public perception that their safety and health was being protected, whether it be by the state agencies, the federal agencies, local agencies, the public's perception was badly damaged. Now, Mr. Smitherman has already eloquently outlined just how important the oil and gas industry is to our state. We didn't know about the recession until a full year after the rest of the country found out about it because of, in my area, the Barnett Shale and the production of natural gas from that shale formation and the jobs that resulted from that. So it is an integral part of the economy, and they're all linked together. So I would just ask the question of Dr. Armendariz, if he was here, what did you attempt to accomplish, and what do you think you did accomplish by making remarks like this? Now, unfortunately, with Dr. Armendariz, there's a history of not meeting with people. I reached out to him at several points to have a discussion. I had met with Richard Green, the previous Region 6 administrator. In the Bush administration, we had a good relationship. We met several times over the 6 years that he and I co-located in the 26th district. I met with Mr. Coleman since Dr. Armendariz has left, so I've already established a relationship with his successor. I was not successful in securing a meeting with Dr. Armendariz, and then, as we all know, at the end of April, the Deepwater Horizon blew up, and that took a lot of his time. So, unfortunately, it just never happened, but it wasn't for lack of trying on my part. Let me just also reference the comments that were made by Chairman Emeritus Barton, or the question that was asked actually by Mr. Rush to Chairman Emeritus Barton about the health officials, and I would welcome the opportunity for health officials to come to this committee. Mr. Shaw, as you know, Dr. Shaw, as you know, shortly after I met with you all, or I guess we had a conference call in May of 2010, I also invited in the folks from the Department of Health Services in Texas because there was an ongoing investigation as to cancer clusters, particularly in Flower Mound, Texas, but other areas as well. And although those results were preliminary, and I've not been informed that anything has changed, the resultant study of the cancer cluster revealed that there was no anomaly. And again, I have not had any recent follow-up from them to tell me that that's different, and maybe that would be a good question to ask. But this is, Mr. Smitherman, I think you said it so well. I mean, we need you all, your state agencies, TCEQ and the Texas Railroad Commission, we need you to be functional and working organizations. We need for the public to have confidence that when you're working, you're there on the job, the cop on the beat to protect them, and additional help is needed from the EPA. If it's required, great. They're there as an ally, not as someone who's going to come in with a bludgeon and try to destroy what you're doing. I would just welcome both Mr. Smitherman and Dr. Shaw to make comments on that. You guys have seen this on the ground. Mr. Smitherman, I guess you weren't there when Dish was having all of the problems, but since then, let me just ask you the question. Did Dr. Armendariz do any good for the long-suffering people of Dish, Texas with his remarks that night?
No, he didn't do any good. And again, what we come back to at the Railroad Commission is these investigations should be grounded in science and the facts, not in an anti-fossil fuel agenda. Because when they are grounded in science and the facts do come out, and it is determined without question that the gas was naturally occurring, it was from a different formation, it was unassociated with the drilling activity in the Barnett Shale, that gives everyone the confidence to allow this process to continue. And this process is creating this wonderful bounty of oil and gas that we have, leading us to energy independence and creating great jobs, not only in Texas, but throughout the Southwest and across America.
Yes, Dr. Shaw.
You have time. Let me, if I can, quickly say the role of TCEQ is the enforcement agency for environmental rules in the state of Texas. So we were engaged in DISH in enforcement, and the reason that we don't see an impact of what Dr. Armendariz accomplished is because we were already on the ground. We were already there making certain that those rules were being followed and were being protective, and so that was not, there was not a need for him to step in.
Thank you.
The gentleman's time has expired. At this time, I recognize the gentleman from Texas, Mr. Gonzalez, for 5 minutes.
Thank you, Mr. Chairman. And before I pose any questions, I want to give some context. more activity logically means more attention. So this is a story from the San Antonio Express News way back in July of 2010. We could update it on the numbers. Texas supplies 20% of U.S. oil production, 25% of natural gas, 25% of refining capacity, and 60% of chemical manufacturing. So I think there's a lot of activity. Now, there's consequences to that. This is from a story in January 12, 2012 from the same newspaper, San Antonio Express News. Texas coal-fired power plants and oil refineries generated 294 million tons of carbon dioxide and other heat-trapping gases in 2010, more than the next two states combined. Those two states happen to be Pennsylvania and California, by the way. Too bad my colleagues are not here. So there's probably going to be more EPA activity in Texas for all those reasons. Now, the question is posed by some of my colleagues, and a legitimate concern is what's going to be the economic impact? And so I'll just go all the way back to, September 2011 Express News story again, and that is that the Texas oil and gas industry actually was back at pre-recession employment highs as of June 2011. So despite this onerous EPA regional director, obviously Texas is still doing fairly well, all things considered. So that as context. So what I want to ask my two chairs from the great state of Texas is simply, is the United States health and environment better as a result of EPA? Just yes or no.
Well, let me say in particular, Congressman, in Texas, a lot of the benefits we've seen are a result of increased use of natural gas to make electricity. So natural gas is a very clean fossil fuel, and we're using more of it.
And I know, Mr. Chairman, my time is so limited. The coal-fired plants in Texas contribute about 61% of the greenhouse gases. And I know, I'm all for natural gas. I mean, we're producing, we don't know what to do. We have so much out there. I'm just asking a simple question for the legitimacy of an agency such as the EPA, which obviously was created during the Nixon administration. Are we not better as a nation for the work of EPA? And I'm just, Chairman Smitherman.
Here's my response. When the EPA's regulations are grounded in science, then they should be legitimately adhered to and followed. But if you look at the CASPER rule, the MATS rule, and the greenhouse gas rulemakings that are occurring, I would argue that they're not grounded in science.
Okay. But my question is a simple one. I'll get to the science if I can get my last minute, because my next question is going to be about science. Is this country's health and environment, the conditions of our health and environment, better as a result of the EPA to date?
Well, I would speak to Texas, where we've reduced SO2 and NOx dramatically over the last 8 to 10 years for a variety of reasons. I would not fully attribute that to the EPA's actions.
Yeah, Chairman Shaw.
Congressman, I would suggest that during the actions of the last 3 years, our ability to continue improving the environment in Texas has been diminished because of actions based by the EPA. That is, some of our tools that we use most effectively to achieve environmental reductions have been taken away from us. The flexible permit and others have been taken away from us. I like to refer to it as EPA forcing us to chase the wrong rabbits. We're chasing agendas that don't have the environmental and health benefits associated with them, and that takes away from our ability.
And I understand that, but I think both of you are still not addressing the central question, is that there is a federal role to be played as long as it's in a cooperative, collaborative spirit. The attacks today are that we don't have that, and I'm just saying, okay, what is going to be reasonable under these circumstances? Both of you say that good science is not being followed. I will tell you now, when I was a judge, we had expert scientists, we had experts all the time. One side would hire one, the other one would hire. Same facts, same figures, different conclusions. The only way we ever got around that was if we could have some sort of a neutral arbiter that both sides would agree was a recognized expert, and then the court would, from that particular list, appoint somebody. So I'm going to ask both Mr. Chairman and Mr. Smitherman and Mr. Shaw, who should be the arbiter of what is good, acceptable, credible, legitimate science?
I would say it should be done in a collaborative way. The cross-state air pollution rule is a great example of a rulemaking that went forward without any input from anyone in Texas industry, regulators, citizens, or anyone else.
I could agree with the proposition. If that's accurate, of course, it makes sense.
And that is the challenge, Congressman, is that we've not had the opportunity to discuss that science because EPA has failed to engage on the science, because that's the grounds we can work with. And unfortunately, EPA's message has been we're not interested in the science and even following the law. They want to have, for example, the Flex Permit Program go away, even though they didn't have a scientific or legal reason to make it go away.
And I understand the Flex issue. If you're from Texas, you're a little more familiar with it because we've had great discussions with the EPA and Dr. Sustein. I yield back. Thank you for your patience, Mr. Chairman.
Yes. This time I recognize the gentleman from Kansas, Mr. Pompeo, for 5 minutes.
Great. Thank you. Thank you, Mr. Chairman. I want to talk about a specific provision that's in the Clean Air Act, but before I do, Mr. Chairman, Representative Waxman talked about the fact that we thought that the former director of Region 6 was enforcing some hidden agenda. There's nothing hidden about this agenda. I don't think anybody that could reasonably look at what's going on, right? You can read it. You can read it on the pages of Sierra Club, right? We start with Beyond Coal. We go to Beyond Oil, to now Beyond Natural Gas. And I think we're beyond common sense is where we've really gone today. And so I don't think there's anything hidden about the attacks on the fossil fuel industry from coal to natural gas and all the others. I want to talk about the general duty clause of the Clean Air Act. I've started to read about lots of enforcement actions under this provision. It is exactly what it says, a general duty. It defines, it says a stationary source has a general duty to be safe when handling extremely hazardous substances. There's no definition for safe. There's no definition for extremely hazardous substance. And Region 6 is the perfect example of what happens when you have provisions that are this general. They engaged in over 83 oil and gas production inspections and wrote over 23 administrative orders under Section 112R in Region 6 with hundreds of thousands of dollars in fines. In their own report, they talk about using infrared cameras in the Barnett Shale area to find gases that are escaping and issuing citations under the General Duty Clause. They conducted aerial surveillance in Oklahoma. Mr. Sullivan, I don't know if they were looking for you or if this was a more general expedition, using aerial surveillance to find gas leaks at different places. Just wondered if any of you, Mr. Smither and Mr. Shaw, Mr. Sullivan, have any comments on the impact of the enforcement techniques being used under Section 112R, this General Duty Clause? Any of the three of you?
Sure, Congressman. I'll certainly chime in that we use the infrared camera as a great tool. One of the things that, back to this science and making sure that we have enforcement that makes sense and is fair and just, is that recognize that technology is not able to quantify emissions. It can identify when there is an emission occurring, but we always follow up with our proven technologies to make sure we can quantify and accurately determine what emissions are so that we can take the proper enforcement action if and when necessary.
The only thing I would add, Congressman, is earlier we heard about the deterrence theory of enforcement, and I would say this is an extremely slippery slope. If we're going to allow regulators to go forward without any evidence just because there might be a problem, then we have completely unbridled regulation, and that should never be the case. It should be always grounded in a reasonable belief in science.
I appreciate that. I'm actually drafting some legislation to try and force the EPA to put definitions around this and quantify and use science-based approach instead of a very general, very unspecific thing that is just prone to enforcement abuse and enforcement that's inconsistent across regions and across the country. With that, I yield back my time, Mr. Chairman.
Gentleman's time yields back. At this time, I recognize the gentleman from Virginia, Mr. Griffith, for 5 minutes.
Thank you, Mr. Chairman. Appreciate all of our witnesses being here today. I would like to start with a little correction in history. While we have been referring to Mr. Armendariz' comments, he got his history all wrong. It was not the policy of the Romans to go into a village and crucify people to hold the village in check. There may have been, because history is not complete, there may have been a rogue actor somewhere along the way. But I think it's important that we don't perpetuate his statement as if it were fact. It may have been his opinion, but it was not historical fact. And in the history of Western tradition, obviously there have been many brutal acts committed along the way. but with rare exception, it was not the policy of any regime to execute individuals in any manner willy-nilly without some cause. We may not have agreed with that cause, but generally, and there are some exceptions, but generally that has not been the case. And so I would hope that anybody who might be studying this would not be thinking that that was real history. It may be history in his mind, but not the facts. That being said, Mr. Shaw, you started on one of the questions previously to talk about the last 3 years and the fact that you've lost some of the weapons that you've had to try to make health concerns better. Could you expand on that for me, please?
Sure, thank you. It ties into the reason that the concerns, that the statement that Dr. Armendariz made were concerning. It's not because of the statement itself, it's because it was reflective of what wasn't a rare glimpse. It was a common thread where we see the current EPA willingness to circumvent good science, to circumvent their own regulations, and that showed up not only in some of the enforcement cases you've heard about today, but it was also very prevalent in the flexible permit program, which is an innovative process that we had that was and should be held up as a very necessary process for moving forward to get additional reductions in emissions. It's prevalent in the process that was used in the cross-state air pollution rule, whereby EPA subjected Texas to that rule without the opportunity for us to comment on data and correct those data so that we could indeed have more meaningful regulation. Having that does a couple things. One, it makes us chase the wrong rabbits. We spend resources, time, money, and others trying to get these improvements where there's no real environmental benefit because the science is not there and the benefit's not real.
Are you saying that you're chasing the wrong rabbits because they may be basing their opinion on some false fact or some false historical fact like the previous one mentioned, or some other false science, and therefore you're having to chase that down and correct that record before you can go on to help clean up something that's a real problem?
It's both. Bad data, which is unfortunate this day and time. We should all make sure we have the best data, and we would have been happy to provide more accurate data to EPA for their analysis. It's also their analysis that they utilize, which again is very difficult to analyze because they're not forthcoming in sharing that process. And then finally, it's the way they apply. For example, to be very brief, but in the CASPR, the Cross-State Air Pollution Rule, EPA was subjecting Texas at the time to a 47% reduction in SO2 emissions from July until December. We were supposed to come up with those reductions based on a model which is flawed and very challenging to use in any case, that's predicted that we would have a 0.18 microgram per cubic meter, a very, very unmeasurable component to a monitor in Granite City, Illinois, which you couldn't measure, couldn't monitor, and at the same time EPA's own data show that that monitor is in compliance and will be projected to be in compliance continually. And so we were going to be looking at spending millions of dollars for no real environmental benefit. And ultimately what you see the common denominator in many of these rules is it was going to put much coal and other electric generation out of business.
And that touches on Mr. Sullivan's comment that if you're using capital for these things, you don't have capital available to expand other jobs or industries. Is that correct?
That's correct. And quite frankly, our generation capacity in Texas is suffering because people are hesitant to build new generation capacity because of that uncertainty.
And Mr. Etcity, am I correct in assuming that if the facilities that you mentioned in your testimony are not allowed to go forward, that will cause economic stress and loss of jobs in the Navajo Nation?
Thank you for the question, Congressman. Yes.
And would it be fair to say that if you had a similar situation like my district, which is heavily dependent on coal, both for jobs and production of electricity, that the same would be true there, or any other area of the nation where people are relying on their natural resources?
I would say it's a similar situation, yes.
And so the policies of the current administration, by not working with you all, are in fact killing jobs, or could kill jobs.
That is correct.
Thank you. I yield back my time.
Congressman, if I may add, in Texas, had we not got a 6-month delay in the CASPR rule, we would have seen 2 coal-fired plants shut down and the elimination of at least 500 good-paying jobs.
Thank you very much for the addition.
This time recognize the gentleman from Illinois, Mr. Shimkus, for 5 minutes.
Thank you, Mr. Chairman. Thank you all for coming. We've gone down this path numerous times, and part of it's the administration's own doing. And we aired the clip from his San Francisco Chronicle editorial board, which he basically says, my goal will be to bankrupt the coal industry. Isn't it any wonder why that sector is concerned, the fossil fuel sector in this country? and then you add to the Region 5 administrator down there, boiler mac, mercury mac, cooling towers, attack of current generation, attack on future generation greenhouse gas rules. And that's, Dr. Mintz, just a quick answer. I should really read your analysis a little bit better. Have you done stuff on EPA in your analysis? Have you done things on the cost of compliance and litigation before the rule gets promulgated, the cost of business, the environmental community going and using the courts versus regulation, court ruling, and then the judgment fund paying off the litigants? Have you done any analysis on that and the cost of the effect of doing business?
Well, no, sir. Most of my research on enforcement doesn't focus on those issues, which are really policy issues and regulatory issues.
But there is, you would agree that there's a cost of doing business if there is then processes moving to a regulatory regime and different communities going through the courts to try to get a new standard outside of their whole regulatory process, kind of shortening their ability. You would agree with that, would you not?
I'm not sure I understand the question, sir.
Well, well, it's not. It's really a statement. What we know is occurring is the environmental community goes to the federal courts. We think on encouragement by the environmental community to get a judgment that creates a higher standard versus them going through the regulatory process, and then they use the judgment fund to reimburse the environmental lawyers. Maybe you want to look. Maybe you want to look into that as another research project, and we can have you back and talk about that. But that's
okay. Well, I'll be happy to do that.
No, it's
like to respond. I don't know if you.
Well, I actually want to go to Mr. Sullivan because he made a point on you're not big oil. So let me go through these 3 big oil tax cuts and tell me why you say that is normal business expenses. Expensing intangible drilling cost. Why is that normal business?
Well, first of all, it's a funny phrase to most non-tax folks.
You're going to have to go quick if we get through all these.
Okay, it is the cost, part of the cost of drilling a well, and we are allowed to deduct that just as anybody running an apartment house or anything else would deduct expenses. But it's become a lightning rod because it's in the oil and gas business.
So bottom line is the cost of doing business. So if you're doing income and revenue, you've got to take off the expenses, and that's part of the expenses of operating a business.
Roughly 30–40% of the cost of a well.
How about the manufacturing tax deduction for domestic oil and gas company?
As I understand it, that applies only to very large companies over 500 employees or something of that sort.
They define themselves as manufacturers, so they're getting the same manufacturing tax break that any manufacturing company is getting.
That's correct.
Is that correct?
It means dollar-wise means
no difference.
Nothing to us. Right.
Same process. What about the percentage depletion allowance?
Well, that is simply it's an akin deduction to depreciation of an apartment building. We have a wasting asset down there under the ground.
So you're telling me that the big tax on big oil and their sweetheart tax deals is current tax law that applies to anybody who's in business?
I believe, I'm not a tax expert, but I believe that the major oil companies are not entitled to percentage depletion. I think they are forced to do cost depletion.
So, but yeah, I've got the Illinois Oil Basin, a lot of marginal producers. So these are the ones that are getting lumped in. And would we have marginal oil production in a lot of the small basins in this country without these provisions?
I think it would not only terminate the lives of some those wells that are on hospice, which are marginal wells, but it would also prevent or reduce the cash flow for drilling new wells.
I've never heard that terminology, but I might use it one of these days. I'm sorry. What, Mr. Yes, sir. I'm trying to figure out which one you are. Real quickly on.
Me too.
You said that the Hayes ruling the change is imperceptible to the human eye. Did you not?
That's exactly what I said, to go from $77 million, which is what the state plan called for and met all the goals and objectives, to 705 to $800 million, it's imperceptible to the human eye.
So why would we do it?
That's exactly our point. Why would we do it? And we've been trying to sit down with EPA for a long time, even though the congressman asked me, are they to sit down with us and talk with us? The answer is they are supposed to. They didn't in this case. And as a result, we're continuing to ask for that meeting to sit down and talk with them because we think we can come to a resolution. We just don't think spending $77 million or $805 million is a good investment in resources and dollars. And certainly, from that perspective, the customer is going to have to pay for it.
Thank you, Mr. Chairman. Thank you all.
This time, I recognize the gentleman from Texas, Mr. Olson, for 5 minutes.
I thank the chair, and welcome to the witnesses. Thank you all for your time and expertise, and a special welcome to Commissioner Smithman and Commissioner Shaw. I know back home, the Aggies of Texas A&M University are will have a little more swagger in their step with you guys up here testifying before Congress Day. So thank you all for coming. And before I get to my questions, I want to publicly express my disappointment that the lone witness for the first panel, the former Region 6 Administrator for EPA, Al Armendariz, canceled out and could not testify before this committee today. I represent Texas 22. Over 920,000 people depend on me up here in Congress to speak with their voices and get answers to their problems back home in Texas. And because they're very concerned that a former regional administrator had a political agenda. His agenda wasn't about any sort of clean water, clean air. It was an agenda about getting rid of American production of energy, specifically fossil fuels, oil, gas, coal. They deserve answers. And unfortunately, he did not come up here today and give me a chance to get those answers. There's no need for me to bring up range resources. I mean, my good friend Joe Barton, the former chairman of this committee and the coach of the congressional baseball team, the Republican side, knocked that thing out of the park. And so I don't want to talk about that. But I do want to focus on a developing problem in Texas, and it's with EPA as well, and this is the Las Brisas Energy Center in Corpus Christi. And so my question primarily would be for you, Mr. Shaw, Commissioner Shaw, but Commissioner Smith, if you feel if the spirit moves you to get involved, please make some comments. But this project right now, Texas, we have the second most populated state in the nation, and we're the fastest growing state. And we're expected to have a 2,500 megawatt shortage in generating capacity, the equivalent to 5 large power plants in as little as 2 years. 2 years from now. So we need power plants being built. The Las Brisas power plant is being built right there in Corpus Christi, Texas. A 1,320 megawatt electric power generating station that will burn 100% petroleum coke, a byproduct of the nearby refineries in Corpus Christi and the Gulf Coast. It will generate enough power to provide power to more than 850,000 homes. And after a 3-year permitting process, the Las Brisas Energy Center received its final prevention of significant deterioration, its PSD, from the Texas Commission of Environmental Quality. But due to EPA's new greenhouse gas regulations released after Las Brisas Energy Center received its permit from TCEQ, the project may have to begin the permitting process all over. Las Brisas could actually provide a net reduction in greenhouse gas emissions by locally sourced petroleum coke by using locally sourced petroleum coke more efficiently and effectively than greenhouse gas emissions from shipping. So my question for you, Mr. Chairman Shaw, is can you give us an update on your progress with EPA and Las Brisas?
I have to be somewhat cautious in discussing because it is a case that is going to be coming back before my agency, so I can't, for ex parte communication, can't talk specifics about that case, but I will concur that the process you laid out is accurate and that with regard to the greenhouse gas regulation requirement, it is somewhat challenging that we have many of these rules that are up in the air and pending, and as we try to have additional resources built to generate electricity, the clock never stops. We get through the process of permit application, and then there's new regulations that come out of EPA, and those also apply, and so there's some challenge with how we ever move forward to getting one completely permitted and able to be built when there's this continual uncertainty that's associated with that, the greenhouse gas permitting requirement being one of those, and the challenge getting EPA to timely act on issuing those greenhouse gas permits because the state of Texas, you're aware, has not agreed to accept that responsibility of regulating greenhouse gases and writing those permits. So it is an ongoing issue, and it has the great potential to exacerbate that problem that you lay out where we imminently need more production. We have about a 2% growth in energy demand each year, and somewhere about 1.5%, I believe, of new generation capacity being brought online, and that's not improving because of the uncertainty associated with pending regulations.
Thank you. Well, again, our first panelist couldn't be here today, so I'm not asking you to use mine, but do you think the fact that he was retained to testify against Las Brisas prior to his role at EPA, do you think that had presented a conflict of interest?
It certainly, if one looks at the challenges that Dr. Armendariz faced, it appears that he had a difficult time transitioning from his role prior to being regional administrator. Much of that we've talked about in the Barnett Shale and others where he seemed to not be able to turn loose of some of the activism activities he had taken prior to working with EPA. He seemed to have a hard time making that transition from someone who's trying to port and push for as an activist to a regulator who has to balance and decide based on the facts and science in the issue. So it's not unreasonable to make that determination.
Thank you. At this time, I recognize the gentleman from California, Mr. Bilbray, for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, before we start, I'd like to say I am sorry that the witness in the first panel didn't show up. And I think there's one thing that both sides of the aisle here on this panel can agree on. I think we'd all be shocked if a local law enforcement officer went into the suburbs of, let's say, Chicago, and had a punitive attitude about a small businessman or somebody engaged in their neighborhood activity, and came out with an attitude that somehow we're going to sock it to one guy to set an example for the rest of the community that I'm here to enforce the law, and even if it's a little overbearing, I'm going to do it. I'm going to profile this guy, and we're going to make a point. I think we'd all be outraged at a local law enforcement officer doing that. And as somebody that's worked with environmental enforcement, I think we should be just as outraged when a federal law enforcement officer for an environmental group, environmental agency, that takes the same attitude. I think it's not just unfair, I think it's immoral, and I think it's outrageous when we think about the fact that we will not accept local people being paid with government funds, taxpayers' funds, and then being punitive against a citizen. But we kind of not shocked that when a federal bureaucrat takes the same attitude with the same punitive attitude, being paid by the same taxpayers, I think we should be just as outraged that this is a violation of everything that this country stands on. And it matters just as much if the federal government is the bad guy here as it would be a local guy. And I think we've almost got this attitude that, well, if they're environmentally leaning, we can justify it. That's the same kind of attitude that justified vigilante groups saying, well, it's law enforcement, it's public protection justifying this violation of common decency and fairness. And I think both sides should be able to address that. Now, I'll say this, and I'll move on, is that as somebody who's operated, been supervised environmental agencies, I mean, let's face it, the air districts in California are pretty darn powerful. I managed one for a 3 million population, bigger than 20 states of the union. And the Air Resources Board has done a whole lot of environmental stuff. I would never accept an administrator taking the kind of attitude that I heard being stated by a federal administrator. And I think this is one thing that we should be able to address. Doctor, I want to get to the details of what you're doing over there. Isn't it true that the original legislation, the Clean Air Act, was sold to the American people and to Congress based on the fact that it was targeted to protecting the public health where no other strategy was going to be able to protect that public health and the innocent bystanders who were going to be impacted by one person's activity on their public health? Wasn't public health the real backbone of the selling the Clean Air Act?
Oh, yes. I think it was, that's the stated objective of the Act, to protect public health and the environment, and that was always what was at the root of it. It still is, I believe. The language hasn't changed.
Yeah. And what we've done is that there's been things like the clear sky issue, the modification of you're crossing away from the public health, which justified the heavy, strong actions that we've taken that have economic impact. We've moved away from that into fields that were never intended originally by either the public that wanted the Clean Air Act or those who passed it originally. And now we've reached a situation where we get these conflicts with what's happening in New Mexico, and the way the EPA has handled that comes right into conflict with, I'm trying to remember the California bill, 1368, and coming into conflict with our strategies on greenhouse gases, where now you're saying that is California going to be forced to change our greenhouse gas strategies because it appears to be in conflict with what EPA is trying to do in New Mexico, and that is our people are saying we cannot legally pay for electricity that is, or if that electricity rate is going to pay to retrofit a coal plant that is being mandated by the EPA. Doesn't that create sort of a catch-22 between federal and two states?
Well, that's been an argument that's been made in litigation, and there were counter-arguments made in litigation as well, and I guess that's before a court. I think the Clean Air Act has been changed over time. It was amended in 1990 to add some provisions, including the Hayes provision that was mentioned earlier. At the same time, the fundamental structure of the Act was not altered in 1990, and the thrust of the Act toward protecting the public health has not changed, and that's still an important part of the statute.
Well, let me tell you something. Somebody that was on the Air Resources Board at the time, we were very concerned about the modifications in the early 90s. And we warned the federal government of mistakes they were making. In fact, if you remember, that was the time he started requiring those of us in California to put ethanol in our gasoline when we warned them, the EPA, that it was a terrible mistake then. So mistakes have been made, and it's interesting you bring that up. I'd just like to thank you very much for being here today and be able to raise these issues, and hopefully we can get both sides working together to avoid these problems in the future. Thank you, Mr. Chairman.
Thank you.
This time I recognize the gentleman from Louisiana, Mr. Scalise, for 5 minutes.
Thank you, Mr. Chairman. I appreciate you holding this hearing, and I appreciate the second panel for appearing before us today to answer the questions that we have. I share my colleagues' disappointment and anger with Mr. Armendariz for not showing up today. And if you go back, we've had many attempts by this subcommittee to bring him before our committee when he was in his official capacity at the EPA. And for whatever reason, he was not allowed to come testify. The fact that now that he's no longer there, he had finally agreed to come testify, and then at the last minute canceled out, suggests that there may be some foul play. And I do think, Mr. Chairman, we ought to look into whether or not there was any influence, any bullying, any intimidation by the White House or EPA or anyone else in this administration to get Mr. Armendariz to not show up, because he had finally agreed as a private citizen to come and answer some of the questions that our constituents surely have about the agenda he was carrying out at the EPA. And the fact that this is not an isolated incident. If his was the only division within EPA that was carrying out this kind of radical agenda, it would be bad enough, but the fact that we're seeing it from other divisions within the EPA begs a lot of questions throughout their various regions, but I think it goes well above his pay grade, and the fact that he had agreed to come and at the last minute backed out suggests that there may have been some bullying and intimidation going on by some people who didn't want him to come here and answer these tough questions that many of us had. And so hopefully, Mr. Chairman, our committee can look into that, because I think there are a lot deeper questions now to ask than just the ones we had from Mr. Armendariz before this hearing was scheduled. Now, I want to go into some specific questions. Mr. Sullivan, you in your testimony talked about him coming before your agency, your organization, and speaking at, I guess, an annual meeting that you invited him to. And from your testimony, it seemed pretty clear that he was not just there to be a regulator. You know, in our view, a regulator is a referee, somebody that's showing up there with the zebra-striped jersey, just implementing the rules, calling the plays as they see them, and making sure that both sides are doing everything by the rules. From your impression, it seemed like that was not the case at all, that he was actually there to carry out an agenda, which is not the case of what a regulator is supposed to do. Can you share with us, expand a little bit on what your experience
Certainly
was?
the impression, let me make it absolutely clear. I may be the only producer in the room, but I want to be clear that we as producers welcome regulation, responsible, fair-minded, fair-handed regulation. We get that from the Oklahoma Corporation Commission, which is the equivalent of the Texas Railroad Commission. Now, when we also have to comply with certain federal regulations, but mostly the oil and gas industry is regulated at the state level, and it's our strong feeling that that's where it should stay, because there are, as has been said, very uniquely, very separate and unique circumstances in each state, having to do everything with the rock, from the rock to the practices to the streams and everything else. And it's best handled at state level. But having said that, to the extent that we're involved in federal regulation, we don't mind that as long as it is conducted the way the Oklahoma Corporation Commission does and the Texas Corporation Commission, which...
And just like we do in Louisiana, where
and
we fracture wells, you've got to think 100,000 wells hydraulically fractured safely in Oklahoma.
There are 800,000 wells that have been drilled in Oklahoma back from literally 100 years ago. And I invite you to come down. We don't live in a cesspool. It's very well regulated and very well implemented. So I think the main thrust of my remarks is that the attitude that came across from Mr. Armendariz is not unique to him. It pervades the EPA, and we don't understand why it can't be as it should be, which, collegial, fact-based interplay.
Yeah, and I think, if you look at agencies, take the FAA, for example. I mean, when there's a plane crash, it's a tragedy. Yet you don't ground all planes. You go find out what happened in that incident, and you do all the things you can with the science to make sure it doesn't happen again. But in the meantime, you allow the industry to move forward. I don't think we've seen that from this entire Obama administration as it relates to American energy, unless it's wind or solar, where they'll go take a gamble and a bet on something like Solyndra. But whether it's coal or natural gas or oil, there seems to be a bias against all of the above. Surely not for all of the above. And if I can, Mr. Shaw and Mr. Smitherman, if y'all want to add anything to the experiences that y'all have had as people on the state level who are dealing with the regulations and doing the things you need to do to try to produce and make sure your state can create the jobs that it does.
Sure, and I'll simply state that as the primary environmental regulatory agency in the state of Texas, the comments that Dr. Armendariz offered were, as you mentioned, indicative of the overall philosophy of the agency, and it wasn't the first time that we had heard him, and he wasn't the only one who made comments that concerned us with regard to their lack of following the rules and law, and he made that comment to his staff expressing what EPA's philosophy was, not as rhetoric at a town hall meeting. It was comments he initially made to his staff, and that's the concern, is it clearly explain, illustrate that philosophy that is not successful for having a successful environmental program.
Congressman, I would add to that the statements and the actions of the EPA in Texas would appear to have set in motion similar actions in Pennsylvania and Wyoming. For example, in December of 2011, a draft report out of Wyoming said that the EPA believed there was a likely association between groundwater quality issues and fracking. That came after the EPA initiated in Texas. We now know that the EPA has walked back those statements in Wyoming and in Pennsylvania.
But the damage is done.
Correct.
Thank you, and I yield back the balance of my time, Mr. Chairman.
Well, thank you very much, and I certainly want to thank the panel. And before we conclude the hearing, Mr. Short, I noticed you appeared to want to say something when Mr. Bilbray was asking questions about the conflict between federal law and state law as it relates to the San Juan generating station. Did you want to make additional comments about that?
Well, I just wanted to agree with that. There are some issues with that. I also wanted to make it clear what Congressman Waxman asked a question about the EPA sitting down with us. The real question is getting them to the table. That's been a problem. We were not consulted during the rule itself, and so that's been a problem. And again, wanted to say that we did put a plan, New Mexico did put a plan together that would meet the objectives of the rule, and EPA said it wasn't good enough, and essentially is mandating the larger expenditure of, 750. I said 705. I'm getting my 5 and the zeros mixed up with the $750 to $805 million. So I wanted to be very clear on that, and there is problems with California as well, increasing the level of mandates that we as utilities are required to meet, and now with this additional piece on top of it, it continues to drive the cost of serving electricity up to our consumers, which are your consumers as well.
Okay. Well, thank you, Mr. Short, and I want to thank all of you.
Mr. Chairman, just before we wrap things up, Mr. Scalise from Louisiana brought up an excellent point. I mean, Dr. Armendariz is not here today, and as a private citizen, that is his right. But I think we also should have available to us any information exchange between Mr. Armendariz and the White House as to whether or not he would testify today, because it seemed like he was quite agreeable to coming and defending his positions, and then he wasn't. And with all of the stuff that we have been dealing with the backroom deals on the drug negotiations, I just feel like we need to look at that and find out if there, in fact, was any communication between Mr. Armendariz and the White House regarding his testimony here today, because as a private citizen, they should not interfere with that activity either. I fully respect his decision not to come. That is his decision as a private citizen. But at the same time, we need to know the back channel information on that. Yeah. And I would just encourage the committee to follow up on that. And I'll yield back.
Well, thank you. And as I said in my opening statement, we do intend to explore the reasons behind this. So once again, thank you for coming. The testimony was quite enlightening, and I must say that when those people who are dealing with Region 6 alone on a regular basis, we do, from the testimony, see a bias against fossil fuel, lack of collaboration, and frequently insisting on FIPS instead of SIPs, which are frequently meeting the requirements of the acts that EPA enforces.
Mr. Chairman,
yes, sir.
I got to respond to my friend from Texas' remarks. I mean, there's no basis for his allegations or his request for inquiry into the actions of the White House. I don't know what that's based on. And certainly, you know, to me, this speaks of proverbial witch hunting. I mean, you know, let's use the resources of the American people. Let us use those resources in a more productive manner. You know, it's just kind of insane to be trying to determine whether or not the White House has asked the proposed witness that he will come and or not show up at this hearing. It doesn't make sense. And I certainly want to go on the record as being strongly opposed to that.
Well, thank you very much. And we do have very strong feelings about Mr. Armendariz, and I don't think there's any question that he has poisoned the well in the enforcement of EPA laws in Region 6. And he had agreed to come, and then yesterday his lawyer said he would not come. And I don't know that we're going to take any formal action or not, but we intend to have some further discussions with him, and then obviously the committee as a whole would have to make any decision. But thank you for your comments, and thank you all very much. As I said, it was very enlightening, and we look forward to working with you as we move forward for hopefully a more collaborative effort in enforcing our environmental laws. Thank you. The record will remain open for 30 days.